How are you doing, Mr. Bill?
Not too
You're not too good? Are this is a medical issue?
Yeah, with my hand, I can't use this hand.
Oh, so there's something wrong with your hand?
Yes, I got shot. No, I got shot.
I remember that.
Months ago.
Yeah, I remember you said it. So your recovery is kind of slow?
Yeah, real slow.
Right.
All night thing.
Oh, okay. Now, Mr. Bill, you're represented in your case by your attorney John West. This prosecutor's coming. Mr. West, how are you doing?
Good, Your Honor.
That's good. State is represented in this case by attorney Kobe Hoffhart. And Mr. West, what is your announcement in Mr. Bill's case?
Your Honor, last time we announced we wanted a little more time to let his recovery continue. He's still having some medical issues. So I think that might be the best is to go ahead and move it to another date if that's okay with Mr. Bill. I think that's probably the best thing. Check to see if him.
Fine, Your Honor, it's not.
Okay, we're gonna reset it. Give us a reset date. Okay, this case is reset to October 13th. Mr.
Okay.
Bill, you're gonna get your from our court coordinator while you're here in court. And we were praying that you have a full recovery. All right, Mr. Bill, just have a seat and wait for your name to be called. And Mr. West, your reset will be sent to you. Mr. West, you're free to go and you have a blessed day.
Thank you, Your Honor. Have a good weekend.
All right, same to you. Which one?
One more for you take time. Thank you. Yeah, just
You say on page 5?
Hold on.
That was just
No, we already did that.
dismissed.
I just
It wasn't that dismissed?
Oh, you just.
Shauna Echo? Then I said, was that a dismissal?
It was one of those.
Oh, it was.
Fruit chop. It was.
Was it Echoes? Maybe not. Okay, it was a different one.
There was Shaw. There was Al Hernandez.
Do you have a stack of the dismissals that he signed? Okay, let's call that case then. Case. Yeah, that one is to be dismissed. Ogden. Ebony Ogden.
We only have 3 of them.
Okay. Next case is cause number M333702, case of style of the state of Texas versus Shauna Trey Eckel. Shauna Eckel was scheduled to be in court this morning for 9 o'clock for the court's announcement docket. At about 9 o'clock, court's bailiff called the name of Shauna Eckel. Shauna Eckel did not appear. Shauna Eckel has not been in court since the court has been in session. The time now is 11:30 a.m. on today's date of August 4th, 2023. Mr. Bailiff, would you please call the name of Shauna Eckel at the courthouse door? Yeah, Mr. Bailiff, would you please call the name of Shauna Eckel at the courthouse door? Shauna Eckel's name was just called at the courthouse door. Shauna Eckel did not answer. A reasonable time has passed to give Ms. Eckel an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
They moved the ball.
That motion would be granted. Shauna Eckel bond will be forfeited and the warrant shall be issued for her arrest. At this time, this will conclude the calling of the court's announcement docket. The court will be in recess for our jury trial. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M327596. Case is filed the state of Texas versus Patrick Daniel Gallagher. Let the record reflect that Mr. Gallagher is present in court with his attorney, Attorney Dustin Galmore. The state is present with Assistant District Attorneys, Attorney Erica Porter and Attorney Kobe Hoffbauer. Let the record also reflect that the jury is not present in the courtroom. State, are you ready?
Say, sir.
Defense, are you ready?
Right.
Okay. On today's date of August 4th of 2023, on yesterday, the court ended after hearing, instructing Mr. Galmore. Yeah, it was a testimony. Actually, that was the video testimony.
Video and testimony simultaneously of Officer Parker. We're in the room, direct examination.
Yeah, we was in the middle, right, of the direct examination, but at one point, there was a video, the video was shown, and there was redacted portions of the video that was not on the video. However, there was a portion that where Officer Mitchell, Detective Mitchell, was on the telephone, and he mentioned the words HGN. Is that correct?
That's correct. Only HG.
Right.
Would be clear, I think, I don't remember if we dictated into the record what the actual statement was. Do you know? We did not do that? Or you don't remember? I believe the statement was
It
after,
was prior
prior to him.
HGN. That's it.
Well, let's just make sure. I want to make sure.
Could we look at the video?
Because it's not on the record. You know what I mean? I mean,
Right.
Yeah, thanks, sir.
just make sure we get the exact same.
No. Wounds. I'll play it from here. And let me. Give me a second. 1909. On video.
On the video, 1909?
1909.
Okay.
Not even much. Oh.
Patrick, unfortunately, here's where we're at tonight. Based on what went on scene doing the test, I do believe you had a little too much to drink to be driving. Just want to take you put your hands on your back, sir.
All right. Officer. Curtis, how you doing this morning? I mean, this afternoon.
I'm doing well,
All
sir.
right. Now, at this point, you made it, you said on the video that you made a determination or, through everything we observed in your investigation,
Yes, sir.
that you were gonna place the defendant, Mr. Gallagher, under arrest on suspicion of being a guy.
Yes, sir.
Okay, now. What led you to that determination? Would you tell the jury what all led you to that? Was it just one thing, the bloodshot eyes? Or was it one thing, less smell of alcohol?
Yes, sir. It was a combination of, from my first approach to the vehicle, being able to, beginning with me smelling what I believe to be an odor of an alcoholic beverage from the vehicle, and making contact with the defendant, being able to, as he spoke to me, smell that get stronger, see the red bloodshot eyes, hear the slurred speech, the lack of dexterity with his fingertips as far as, he tries to provide me with his driver's license. He ends up grabbing the driver's license and the credit or debit card, providing that to me. Then whenever I asked the defendant to step out of the vehicle, as he steps out, what I believe to be beer spills out of the side of the truck onto the ground next to the truck from an open container from within the vehicle, and then leading to his performance on the walk and turn test, his performance on the one leg stand. The combination of all these things, along with him going and seeing the open container in the vehicle, led me to believe that Mr. Gallagher was driving while intoxicated. And based on the totality of those circumstances, I placed him under arrest.
And just to be clear, you're saying that you believe that you had sufficient evidence that Mr. Gallagher, and I don't want to put there what Mr. Gallagher lost the normal use of his mental or physical faculty.
Yes, sir.
And due to intoxication.
Yes, sir.
Okay, and what about mental faculties? That's included in the list, if you want to put it, correct?
Yes, sir.
Okay, and physical faculties as well, because it's on the video. Is
Yes,
that
sir.
correct? Correct. Now,
Judge, at this time, I believe the court needs to give an instruction. There was a ruling by the court.
Okay, you asking for an instruction now?
Yes, Judge.
Okay,
for the
you
individual.
can turn on the lights, yeah. Mr. Okay, now, Mr. Galmore, your objection is to a portion on the video, is that correct?
Judge, based on the court's prior ruling that the court was going to give an instruction, I would ask the court to give that instruction before we move forward.
Okay. Now, well, ladies and gentlemen of the jury, at this time, the court is going to ask you to disregard the statement that was made prior to the HGN. You're gonna, and at this time, the court is, first of all, the court is gonna ask that that be stricken from the record.
Yes, Judge.
Okay, that will be stricken from the record. And the court is instructing the jury to disregard any mention of the words doing prior to doing the HGN. Does everyone understand? When I say disregard, that can't be mentioned in your deliberations. To disregard it. Okay. All right, next,
See, girl.
yes.
Perkins. I just want to make sure it's clear. You had enough, you believe you observed enough in your investigation to arrest Mr. Gallagher on May 7th, 2020 on suspicion of driving while intoxicated. Is that
Yes,
correct? Okay. And it was due to the totality of your investigation.
Yes, sir.
Now, At that point, did you place, as we saw, place Mr. Gallagher under arrest?
Yes, sir, I did.
Did you feel you had sufficient evidence at that time?
Yes, sir.
Okay, now, did your investigation of Mr. Gallagher on May 7th, 2020 end, even though you placed him under arrest?
No, sir, it did not.
Okay, what did you do next?
After placing Mr. Gallagher under arrest, we'll see shortly, I placed him in my car and then I read him the DIC 24 statutory warning.
Did you get reading Miranda rights as well?
Yes, sir, I did.
Okay, and that's something standard that you do on cases like this, not even DWI, place them under arrest, you read their Miranda rights. Is
Yes,
that correct? Okay, and that's on the video.
yes, sir, it is.
And then you said you went on the DIC 24. Tell us what that is.
The DIC 24 statutory warning is after a person's placed under arrest for an alleged driving while intoxicated. It's a statement of that they have been arrested, and then it explains that a specimen will be requested of them, either breath or blood, and then it explains the consequences of providing or not providing that specimen.
Is that included on the video as well?
Yes, sir, it is.
I'm gonna play that for the jury now.
Okay.
Under arrest for driving while intoxicated. Every time you get back. Why don't you get your parents back with you, please? Our policy is that you don't make them have fun. It just depends on what tow truck is up on the dictation. Hold on, just a sec, okay? Yes, sir. Let's see. I have to read you Miranda warning. So you have the right to remain silent. Anything you say can be used in court of law. You have the right to talk to a lawyer and have them present with you while you're being questioned. Cannot afford to hire one. One will be appointed to represent you before any questioning. If you wish, you can decide at any time to exercise these rights and not answer any questions or making a statement. Just anytime making an arrest, we do have to read that. Give me just 1 second. Package, I have to read the statement, I have to provide it to you in writing. So I'm providing it right here where you can read along with it. You're under arrest for an offense arising out of acts alleged to have been committed while you were operating a motor vehicle public place or one correct, while intoxicated or an offense under section 106.041 alcohol. You'll be asked to give a specimen of your breath and or blood. The specimen will be analyzed to the alcohol concentration or presence of substance, drug, dangerous drug, or any other substance in your body. If you refuse to give the specimen, that refusal will be in subsequent prosecutions, your license, permit, or privilege to operate a motor vehicle will be suspended or denied for not less than 180 days, whether or not you are subsequently prosecuted for this offense. If you refuse to submit to the taking of specimen, the officer may apply for a warrant authorizing a specimen to be taken from you. If you're 21 years of age or older and submit to the taking of a specimen and an analysis of that specimen shows that you have an alcohol concentration of 0.08 or more, your license, permit, or privilege to operate a motor vehicle will be suspended or denied for not less than 90 days, whether or not you're subsequently prosecuted for this offense. If you're 121 years of age and have any detectable amount of alcohol in your system, your license, permit, or privilege to operate a motor vehicle will be suspended or denied for not less than 60 days. However, if you submit to the taking of a specimen and an analysis of the specimen shows that you have an alcohol concentration of less than 0.08, you may be subject to criminal penalties less severe than those provided for under Chapter 49 Penal Code. If you were operating a motor vehicle and you refuse to get a specimen or provide a specimen that shows you have an alcohol concentration of 0.08 or more, you may be disqualified from driving a commercial motor vehicle for a period of not less than 1 year. You may request a hearing on the suspension or denial. This request must be received by the Texas Department of Public Safety at its headquarters in Austin, Texas, no later than 15 days after you received or are presumed to have received notice of suspension or denial. The request can be made by written demand, fax, or other forms prescribed by the department. I certify that I've informed you both orally and in writing of the consequences of refusing to submit to the taking of a specimen or providing a specimen. I have provided you with a complete and true copy of the statutory warning. I'm going to request a specimen of your blood. Are you going to provide a specimen of your blood?
I'll get on spot anything, yeah, just bring me the jail, okay?
Yes, sir. Thank you.
Officer. On station exhibit number 1, we've been watching. Did you hand the offender or show him while he's handcuffed and read to him while you're showing him a copy of, we call it the IC-24?
Yes, sir.
Is that correct? Okay, we're showing you what, may I approach it?
Yes, you may first.
I've been showing you with the previously marked as station exhibit number 2. I apologize. I can turn the lights on. Do you recognize that?
Yes, sir, I do.
Okay, what is it?
It's the DIC statutory warning.
Is that the exact one that you read, or a copy of that form and the warnings that was just read aloud on station exhibit 1 included? That's the document.
It was a
Okay,
copy of this form.
Copy of that.
Yes, sir.
And why do you have a copy of that, the form? But it looks like it was laminated. Is that
Yes,
right?
sir. I keep a laminated copy of it in my bag.
Okay. Why do you have a laminated one versus flimsy sheet?
It's more reliable to stay together, and I've also unfortunately had people throw up on it.
Okay. Now, but this one was the sheet you said, and it's exact language that you read in the defendant, right?
Yes, sir.
And later on, did you get the defendant, there's a place on this, did you get the defendant to sign what he said after your interview? Meaning, like, was it the one, this original here, was you get the defendant to sign that he would not give or refuse it?
Yes, sir.
Now, in Station Exhibit 2, so it was a copy of the warning sheet you provided the defendant? Correct.
Yes, sir, it was.
Right. Now, and his handwriting's on this sheet, is that right,
Yes, sir.
Mr. Gallagher? Now, did he agree to give a sample of blood?
Not at that time, sir.
Okay, now, tell the jury, the officer has a choice, is that right? About whether to take a breath sample or a blood sample.
Yes, sir, we did.
Explain that to me. Yes. Okay. If you would. Tell us how that works in the normal time, not during COVID. Okay, how does it work?
Typically, after a person's been placed under arrest for driving while intoxicated, we have the option to use an intoxilizer and get a breath specimen for them. Or we can do a blood draw either at the jail in the medical wing, or we can do it at the hospital. So that way we're able to obtain that specimen of what their BAC is at that time of the draw.
So, I apologize, I'm gonna stop, but BAC, what does that stand for?
That's a blood alcohol content.
Now, so you only offered him blood, could you have offered him breath on May 7th, 2024?
No, sir, I could not have.
Why is that?
Unfortunately, whenever the coronavirus struck, the Jefferson County Jail stopped allowing us to use the toxilizer for DWIs and requested that all DWIs be done by a blood draw.
And that would, do you know the reason for that? Obviously, for safety.
Yes, sir.
Okay. Now, did the defendant say he would provide a sample on the video?
No, sir, he did not.
He said, what did he say? We heard it, right?
I think he said, I don't think I'm gonna provide you anything.
Okay. Now, and this represents that. This states different number 2, is that correct?
Yes, sir.
It was read and this defendant's signature here. And would you read that to the jury where the defendant checked and signed his name?
Subject refusal while the taking of a specimen as evidenced by his or her signature below.
Thank you. This time, judge, I'm entering, state exhibit number 2 to closing counsel. Barring any objection, but that's the wrong words.
Okay. No objection, states exhibit number 2 is admitted.
Thank you. Now, what did you do after you talked to the defendant, you refused to give a sample? What was your job at that point?
At that point, I transported Mr. Gallagher to the Jefferson County Jail, and based on his refusals, then logged into we call it the blood warrant computer at the Jefferson County Jail to apply for a warrant to obtain a specimen of Mr. Gallagher's blood.
Okay. Now, did you conduct, when you're stopped on a DWI, do you conduct an inventory? We obviously don't let people under suspicion of driving while intoxicated drive on. Right, so
Yes,
you're
sir.
responsible for the vehicle, correct?
Yes, sir.
Do you conduct an inventory before that is taken by the record?
Yes, sir. Prior to transporting Mr. Gallagher to the jail, I did inventory his vehicle to make sure that any items of value would be noted, so that whenever the tow truck came to pick it up, we could document that those items were in the vehicle, so that they don't come up missing by the time Mr. Gallagher gets his vehicle back.
Now, what did you find in Mr. Gallagher's vehicle?
In the vehicle, there was the beer can that I had located in the front driver's pocket of the door. And then I also located a second 12-ounce Bud Light beer can in the back seat of the vehicle.
Now, were they open?
Yes, sir, both were open.
Both of them would be considered open containers in the state of Texas. Is that correct?
Yes, sir.
Okay, the defendant claim ownership to either one of those things while he say that, oh, that's mine, I was drinking that?
No, sir, he denied both of them.
What did he say?
He said his cousin had been driving his truck earlier, and his cousin must have left those in there.
Okay. Thank you. Oh, yeah. That's it, your inventory is included on the video, is that correct?
Yes, sir. Yeah, that's it. Next up, contract.
standing deep, black can. Double. Forward. Big old. Stop on. Patterns. Okay, one heavy. Better 27 15 seconds. Good. Sunglasses. Baby. All right. Those players.
This one officer had you completed the inventory of the,
Yes, sir. I have.
okay, and you said you observed and it was on the video, there were some open containers in the vehicle,
Yes, sir.
correct? And one of them, I believe you stated was cold to the touch.
Yes, sir.
Okay, now, through your training and experience, what does that mean about an open container that's cold to the touch?
Remember, I said it was cold to the touch. That means that it appeared to me as if not long before me touching it, it had been either in a cooler or refrigerator or something of that nature. It wasn't just cool, it was cold and that condensation coming off the pan.
Now, why did you took his debit card, is that correct?
Yes, sir.
And is that the debit card in which the defendant, Mr. Gallagher, handed you when you requested his license?
Yes, sir.
Okay, did you request a debit card at that time?
No, sir, I did not.
Okay, and you even said, oh, wait, this is your debit card, I didn't ask for that, you handed it back to him.
Yes, sir.
Now, why did you pack up all his personal, I think you went through sunglasses, coastal sunglasses,
Yes, sir.
and his wallet and his debit card, is that right?
Yes, sir.
Why did you do that?
I was grabbing items to bring with Mr. Gallagher to the jail, so that way they wouldn't be left in his truck, so he would have them whenever he got out.
Okay, and are you required to do that, or are they through training, or to do that?
Yes, sir.
And then you did it on May 7th, 2020.
Yes, sir.
Okay. Now, once that's completed, what's the next step in your investigation, or what are your duties as an officer at that time?
At this point, after completing the inventory, I would wait with the vehicle until the tow truck arrived to take possession of it.
Okay, now, because at this point, the owner or the person driving is in custody.
Yes, sir.
And do officers leave vehicles there? That's
No.
property, right?
Yes, sir.
So you're responsible to make sure that it gets towed or somebody comes to get it. And that happens sometimes, like if they've got a close family member, you know, to come get it so it didn't have to be towed.
Our policy as a department that is if we make an arrest out of the vehicle is to be towed.
Okay. That's protocol and dealing with media.
Yes, sir.
Okay, now. From this time, did the record show up immediately or did you have to wait a while?
I don't remember how long I had to wait for it, sir.
And the video would show that, is that correct?
Yes, sir.
Now you did, while you were waiting on the record to come, you're responsible for it, so you have to stay there, is that right?
Yes, sir.
Okay, so did you do any more investigation while you were waiting on the record?
I can't remember if I did, sir.
Okay. Now, so for the purposes of efficiency, Your Honor, and I'm gonna move it ahead so that we get past the wait on the record service.
Okay.
Play at that point. What's the protocol when the record, you wait for it to be taken away, is that right?
Yes, sir.
And then you proceed.
Yes, sir.
Okay. Now, you said you transported Mr. Gallagher to Jefferson County Jail.
Yes,
Is that
sir.
right? Now, to be clear, we stopped that video and it was on for the jury is from 41 minutes on the video to 53:10 is when the record showed up. Does that sound about right?
Yes, sir.
Okay, that's roughly 13 to 15 minutes. Is that correct? Okay. Now, you transported the defendant to the jail. Did anything occur on that transport? Or did you speak to the defendant? Did he make any statements to you?
I cannot remember, sir.
Okay. And now, if it is, it's on this video, correct?
Yes, sir.
Okay, now, I'm gonna play it. Because also included on the video, when you arrive at the jail, you tell the jury what you do in that circumstance, because you're not the only agency. The LMPD is not the only agency that uses Jefferson County Jail, is that right?
That's correct.
So what is your duty once you get there with a person like Mr. Gallagher arrested on suspicion of a driver while intoxicated?
Typically, when we arrive at the jail, we get out and we have lock boxes in the back of our car that we secure any kind of weapon that we have with us, to include our handgun, pocket knives, anything like that, into that box and lock it in the vehicle. Then we'll get the arrested person out of the vehicle and then go to the door of the jail and wait for them to unlock it so we can step into another set of doors that we've been wait on. When that set of doors open, we go inside, and then typically we'll have the arrested person stand in a certain location. And then we'll go to the booking desk to fill out the sheet, advising them who we've arrested, the charge, my agency, and then let the jail staff know while we're there.
Now, was that included on your video body cam?
I cannot remember if I shut my body camera off before I went into the jail or not.
Okay, it is included on the video, so it was on, is that refresh your memory?
Yes, sir.
Okay. At this time, Your Honor, I'm going to skip ahead to that portion.
Okay.
Work business here. For purposes of the record, a state is going to say we moved ahead in the video, and the time on the video is 53. Excuse me, 54:23.
Okay.
And we're going to play it now. One of let me reset that. 1 hour and 7 minutes. 33 seconds.
You have anything in your pockets? Sorry.
It might be money, I don't know.
Around the front vehicle. You can check, John, anything in here, Johnny down. Stand here, this camera, sir.
Okay, is that local one or total? I'm not sure, because about to get a couple for Nashville.
Hello. No, sir, you just have to check, just in case you were to have something, if you're in the jail, with it, it's an additional charge, and I don't know about that. That happened. There you go, Richard, you can. check it in. Yeah.
Get a blood draw.
Yes, ma'am.
Okay.
I'll be right down there on my car.
Yeah, you can rush one.
Yes, sir, I'm gonna bring those in signature properties. Yes, ma'am. It's gonna be a, more letter up. You go.
I'll do- Stop it there. Until last month, we're down. Officer Perkins. You said, we heard on the video, what Stacy Exhibit number 1 is that it would be a blood warrant. Somebody asked you a question, you said it's gonna be a blood warrant.
Yes, sir.
Would you explain that to the jury, what that means?
If a person does refuse to provide a specimen, there's a specialized computer at the Jefferson County Jail where you go in and you complete the forms to fill out a warrant for that person's blood draw.
Now, we heard on Stacy Exhibit 1, Mr. Gallagher, when read the DIC 24, which is included in Stacy Exhibit 2, that he refused to give a sample of his blood, correct?
Yes, sir.
Okay, now, he was given those warnings and he refused, so at that point, what are your avenues, what can you do?
The
A blood
option,
warrant? Is
the
that-
option at that point would be a blood warrant.
Okay, now, did that change Mr. Gallagher's agreement about not giving, I mean, he said he wouldn't give it, did it change that he'll give it, now he'll give consent at any time?
Not at this point, yes, sir.
Okay, was it later on before your completion of your investigation?
Yes, sir.
Okay, how did you receive that information?
I went back to the room where the computer was and was working on filling out the form for the blood warrant. When one of the jailers came in and advised me that Mr. Gallagher had told them that he would give a specimen. So at that point, I left and went back to the bookend.
Okay, now, so he changed whether or not he would provide a specimen voluntarily, is that correct?
Yes, sir.
Okay, now, through your training and experience, have you had individuals like Mr. Gallagher who make one decision and then change it and, therefore things change, you don't need to get a blood warrant?
Yes, sir. I have.
Okay. So, and does that happen often or is that rare?
For me, it was pretty rare.
Okay, but it does happen,
Yes, sir.
right? So what did you do at that point?
At that point, I actually, to make sure that Mr. Gallagher understood what he was consenting to, I reread him the DIC 24 statutory warning. So that prior to him voluntarily giving the stuff, and then he knew what that pertained.
Okay, now, did he sign document like the DIC 24 that he would provide a specimen?
No, sir, he did not.
Did he continue to agree to provide a specimen?
No, sir, not after I read it.
So he went, he hemmed and hawed, he went from one to the other, back to, I'm not giving it.
Yes, sir.
Did he give a reason why he wouldn't give the sample?
He stated he was afraid of needles.
Is that the only way we get a blood draw?
Yes, sir.
And is that normal that we saw a nurse on this, on Stacy Exhibit number 1? We're checking your temperatures. Why was she checking your temperature?
That was during the coronavirus pandemic, and it was the policy of the jail that they check everybody's temperature coming into the jail, make sure nobody has fever.
Okay, malfunction.
Yes,
I'm sure he wasn't previously marked as Stacy Exhibit number 3, which take a look at that. Do you recognize that?
Yes, sir, I do.
Okay, and what is it?
That is a copy of my body worn camera from the blood draw.
All right, blood draw or their portion, not exactly, but there was another portion of body cam that was talking about the testimony you just previously gave.
Yes, sir.
Is that fair to say?
Yes, sir.
Okay. Now, this was on made on a recording device that was working properly at that time.
Yes, sir.
In fact, this is a video taken from the exact body camera that Stacy's doing one.
Yes, sir. That's right.
Okay, so all of that applied, it was working properly. You're a competent operator of that body cam.
Yes.
Okay. Now, is an accurate copy of any conversation that went on May 7th, 2020.
Yes, sir, it was.
And this was where at the jail,
Yes, sir.
also your body cam. Now, can you identify all the voices on this video?
There may be some people on there I do not know.
Okay, were they pertaining to this particular case or talking about this case?
Yes, sir.
Meaning, okay, you're the sole investigator.
Yes, sir.
Correct. Now, this fairly inaccurately represents what happened on May 7th, 2020 that you observed and was put on your body cam.
Yes, sir.
At this time, Your Honor, has it been altered in any way other than placed on an individual thumb drive?
Yes, sir.
Okay. And you reviewed this prior to trial. This time, state's going to offer it. And defender opposing counsel stated that number 3, and barring any objection, the state would ask to admit this.
Oh, before we do that,
Yes.